On public ethics hearing on the new disclosure requirements in the New York State Lobbying Act. The new reportable business relationship and source of funding disclosures are among the most significant reforms to the Lobbying Act since its inception, and the source of funding disclosure for lobbying activity provision is unprecedented. The disclosures required by these new provisions are an important component to the Joint Commission on Public Ethics mandate to better inform New Yorkers about the efforts to influence government's decision-making processes through increased transparency. These new provisions in the law leave open, however, several issues that must be clarified. For that reason, the Commission is developing guidelines and regulations for the two new disclosure requirements. And while it is in everyone's interest, of course, that these guidelines and regulations be developed expeditiously, it is also imperative that the guidelines and regulations be informed, that they be workable, and that they provide for meaningful disclosure. In order to promptly clarify these issues through guidelines and regulations, it's necessary that we do that to provide for maximum transparency for New Yorkers. And the hearing today will serve two purposes. One, it allows us to hear from groups who are affected by the law as to what they think is the most effective and practical way of interpreting the relevant provisions. And two, this hearing and these public comments will give us a chance to ask questions to better understand the proposals that have been advanced as we set about to develop the necessary regulations and guidelines for the provisions. Because of the importance of the disclosure provisions and the complex nature of this undertaking, we anticipate that after the hearing today, we will be open to additional public comment on these matters that are raised. One important note before we begin: everyone should understand that they should continue to file their required bi-monthly and semi-annual reports. What we are doing here today has no impact on that obligation. The law for both of the new disclosure requirements is currently in effect. The form to disclose reportable business relationships is already available on the Commission's website, and everyone should make their best effort to report this information based upon a plain reading of the law. While there may be some questions regarding compliance, as guidance is published, the information reported can and should be amended accordingly. The forms for the source of funding requirement will be made available as soon as the regulations are promulgated. That said, all required filers will ultimately be obligated to disclose the information pursuant to the law. Everyone should maintain their records so that they are prepared to file as soon as the forms are available. To be clear, no one will be relieved of any obligations as a result of any delays in the promulgation of the regulations. Now, to today's agenda. We're going to hear from 5 presenters who have requested the opportunity to be heard in person and have filed comments. They will present for a maximum of 5 minutes, and then the members of the Commission, who I will introduce to you in a moment, will have the opportunity to ask each of the presenters any questions that they deem appropriate. From my left, Commissioner George Weissman, Commissioner Gary Levine. To my far right, Commissioner Batra, and of course our Executive Director, Ellen Bybin, is seated at the table with us. So let's start with our first presenter, Barbara Bartoletti from the League of Women Voters.
And I'm not sure all of you got copies, but if you'd like
Thank you. I'll distribute
comments.
Them. Yes. Good morning, Ms. Bartoletti, and welcome.
Good morning. Thank you very much, and thank you very much for allowing us some input into this process. I'm here today as Legislative Director for the New York State League of Women Voters. This testimony has been prepared by our President, Sally Robinson, who is not able to attend for today, so I will be giving those remarks. The Public Integrity Reform Act of 2011, the Act, instituted new disclosure requirements for lobbyists and clients of lobbyists. The League is suggesting in these comments a few principles to be followed by the Commission in developing guidelines and regulations to implement this new law. Number 1, new reporting requirement for reportable business relationships. Lobbyists and clients are required to disclose, quote, all reportable business relationships, unquote, under the Act. In developing guidelines and regulations for this new requirement, the Commission should specify clearly the circumstances under which a, quote, reportable business relationship, unquote, exists so that lobbyists and clients understand their obligation to report. The form should be simple to understand, and disclosures under this section should be sufficiently detailed so that the public can fully understand the nature of the business relationship. Number 2, source of funding reporting. The Act requires new funding source disclosures by lobbyists and clients who meet specific financial thresholds. Thresholds that the League does not meet, since we are almost entirely a volunteer organization. So although we do not meet any of the thresholds, we have indeed registered. I am a registered lobbyist. Most of the people that do our issues areas are registered lobbyists, although we have never met the threshold. But it's the glass house and the throwing of the stones. Disclosure and reporting requirements for lobbying have been upheld for many years in the courts, and we believe that they play a very important role in informing the public. However, in implementing these new requirements, the Act recognizes a competing need to make sure that fundamental constitutional rights of speech, association, and privacy are protected. 3, exemptions from areas of public concern. One way in which it does this is to provide exemptions for all 501c3 tax-exempt organizations and a subset of 501c4 tax-exempt organizations. If their primary activities are in an area of public concern, such as civil rights and civil liberties, determined by the Commission to create a substantial likelihood that application of this disclosure requirement would lead to harm, threats, harassment, or reprisals. I would add here that during the lobbying for this ethics law that was passed about a year ago, we were concerned that there would be organizations that would, if their donors were disclosed, would sustain serious harassment. And of course, I think in the national arena as we see it today, the primary organization we were concerned with would be the Planned Parenthoods that primarily provide health care to their clients. In coming up with these predetermined exempt areas of public concern, as well as ruling on specific exemption from reporting, the Commission needs to carefully balance the benefit of providing useful information to the public against a legitimate need to protect constitutional rights. The opt-out provision. We also believe that the Commission should establish a straightforward process, and I emphasize the word straightforward process, by which 501c4 organizations can allow donors who want to broadly support an organization's mission to designate contributions for a separate account whose funds cannot be used as a source for lobbying activities. This opt-out provision would give meaning to the Act's requirement that sources, quote, used to fund the lobbying activities reported, unquote, be identified. It could be modeled on a similar opt-out provision in the recently introduced Federal Disclose Act of 2012, legislation that is aimed at disclosing the source of money used for campaign-related disbursements and is strongly supported by the League of Women Voters of the United States. The Commission needs also to establish regulations and guidelines sufficient to look through entities to reach the ultimate source of funding for lobbying activities and thus fulfill the intent of the statute. Again, provisions in the Disclose Act on the federal level that get to the source of money used for campaign-related disbursements, even if the funds are passed through other entities, might be helpful. Transition rules. Unfortunately, the Act we passed in 2011 did not include transition rules. Given this, We believe a fair and reasonable approach is for organizations to report sources of funds received after regulations under the Act are finalized. That way, both the reporting organizations and donors are aware of their obligations. For example, at this point, it is not clear which 501c4 organizations will be exempt from the reporting requirements because their activities are determined to be in specific areas of public concern. I would just now, at the end of the comments, encourage you to do this in an extraordinarily timely manner so that the public does have a very good view of who is lobbying for what issues and before what entity of government. This has taken, as you know, it's almost a year since the Act passed, and the public need to know who is lobbying public policy. And so the more timely you can do this, the more deliberative, thoroughly, but timely that you can do this, we think would be the best course to follow. Thank you very much, and thank you for having the lead here today.
You're welcome. Any questions from any of our commissioners?
Yes. I just want to first thank our distinguished District Attorney Janet DiFiore for the leadership of JCO and our Executive Director Alan Weidman, who has a proven track record protecting the public funds. Ms. Bartoletti, let me first congratulate the League of Women. You've always been a guardian of democracy, and your presence here today is greatly appreciated.
Thank you.
The operative mandate for our commission was Governor Cuomo's greatest transparency in government, and I certainly wish to follow that mandate to the best of my ability. I would ask you, because it's a fact-finding hearing, to kind of guide me through some of my issues. In the past, I've been troubled by what I saw in the aqueduct situation in the prior administration, as I was very troubled by Troopergate. The recent disclosures of this week have left me stunned. What can we do? What would you suggest we do that the public gets to see its government in disinfectant sunshine of Justice Brandeis, rather than needing night goggles so we can get to look at who donors are?
Well, I think that question lends itself more to something that probably will not be discussed here today, and that's an absolute necessity for campaign finance reform. This governor has, as a candidate, it was in his reform booklets, and he mentioned it in the State of the State of 2012, and certainly we have, in over the 3 decades that I have been doing this, been lobbying vigorously for far better campaign finance laws. I know that is not the purview of this commission, but in answer to your question, we must come up with very comprehensive, shall I say, campaign finance laws. Certainly public financing will get, we hope, to nullify some of what the Supreme Court did in Citizens United. And, of course, I think that was stunning to almost every citizen in this state, that a corporation is now a person.
But that's Section 527 of the IRS code.
That's right.
But there's no control between the 527 entity and a campaign or a candidate.
That's right. There supposedly is no operation separation. When you get into independent expenditures and soft money, which is something we would definitely like to be part of, insist on as part of any campaign finance law, that would be, we have housekeeping accounts in this state that are on limited funding. We have soft money that that transfer between parties. We have very high contribution limits, and we have very little disclosure and almost virtually no enforcement of our campaign finance laws. Of the 44 states here in this country that do have campaign finance laws, New York State is by far the most lax. And on top of that, of course, one of our good working relationships is with the State Board of Elections. We've done that for decades and decades, and we try and help where we can as far as the administration of elections. However, one of their axillary missions is to do campaign finance enforcement, and they do absolutely none of that. So that would be my first recommendation, is to deal with the campaign finance reform that I think certainly the governor has talked a great deal about. That needs to be done soon, and it needs to be done in a comprehensive manner. As far as what you folks are addressing today, I think, as I said a little earlier, we just need to get these regulations out to the public so the public understands, the lobbying entities understand, so that we can actually see who is doing business before the state, what their relationship is, so that the public has a very good idea that their voice, whether it's campaign finance reform or here in the lobbying arena, that their voice is not being drowned out by the very big moneyed special interest.
Let me just ask you a question on timing. Do you think that the look back that we're entitled to do under PIRA is limited to June 1 of 2012, or does it go back to August 15 of 2011, the effective date of the bill, or the law rather, or even back to January 1 of 2011?
I believe that our president, Sally Robinson, who is a tax...
Particularly given the ex post facto warning in the Constitution.
That's right. And our president is a tax attorney, and this is her purview. And I believe what we spent some time yesterday talking about this, and her sense is that, no, you should not go back, because the people who legitimately gave funds before your regulations are developed have a presumption that their funding would not be reported. And therefore, it is a basic, in her mind, a basic sense of fairness.
Once the law came into effect, didn't everybody know that the law was in effect and they were going to be reporting on or about June of 2012?
Well, to be very blunt with you,
Please.
Commissioner, I think once the law was passed, most laws have regulations that need to be implemented. To implement it, it took what we did consider at the time a very overly lengthy process by which the commissioners were chosen. Those were legislative appointees. We continued to urge the legislative leaders to get the commissioners into place, and that did not happen for a full 6 months after the law was passed. Then you had to have a chair, and by the time you were up and running, it was February.
I understand. Let me just, because I want to truncate my inquiry and give the...
Yes, please. We're watching the clock.
Yield the floor back to the chair. Are you familiar with Senator Liz Kruger's bill of last year, May of 2011, which went further than PIRA?
Yes.
Are you familiar with its definitions?
I haven't looked at it recently because it did not come to fruition in the legislature.
Do you see any prohibition if JCOB was to consider those definitions as part of its deliberation in coming up with the guidelines and regulations?
I think Senator Kruger is an extraordinarily apt legislator. And yes, and I think any suggestions she may make, we would probably look very fondly on.
Thank you very much.
You're very welcome.
Thank you, Madam Chair.
Ms. Bartoletti, thank you very much for
very
taking
welcome.
the time to come today. We appreciate you informing us. Thank you very much. Next on the agenda is Alex Camarda from Citizens Union. Good morning, Mr. Camarda.
Good morning.
Thank you for being here.
Thank you for the opportunity.
You're welcome.
Good morning, Commissioners of JCOB. My name is Alex Camarda. I'm the Director of Public Policy and Advocacy at Citizens Union. We are a nonpartisan good government group based in New York City. In May, we provided extensive commentary on the disclosure of donors to lobbyists and clients, as well as the disclosure of business relationships to those groups. I'm going to just highlight a few of our recommendations today. I do want to point out that the overarching principle for all of our recommendations is that JCOB should promulgate rules to promote transparency of those who fund lobbying activity. We believe that, and I think this has been indicated in the reports that JCOB has put out for years, that lobbying activity has exploded in the last 2 decades, and I think the news coverage in recent days points to the need for robust disclosure of sources of income to lobbyists and clients. So I wanted to touch on 4 major issues, the first of which seems rather mundane, but is important, and that is the disclosure of names of sources of income to lobbyists. We know from our experience with the campaign finance reform database that the manner in which names are reported is actually extremely important. For the campaign finance database, names are reported in all different ways. You have full names reported, abbreviations, acronyms, and what this does is ultimately frustrate transparency, because when you do a search, it either provides not the full picture of disclosure or sometimes even inaccurate disclosure. And so what we would suggest is that JCOPE actually prescribe how names be reported of both donors and the lobbying entities. In addition, if the law permits, we would suggest that additional information be sought that would clarify identities, including employers and employer addresses. That would help to distinguish donors who have the same names, like John Smith, from each other. It would also help to recognize trends with regard to industries and occupations when it comes to lobbying. The second issue I'll discuss is the definition of the sources of income. We would like to see sources of income defined so that related sources are treated as a single source. And by related sources, I mean subsidiaries of corporations, for example, LLCs, LLPs, individuals that are part of the same family. It's conceivable that these entities or individuals could provide contributions to lobbying entities just below the $5,000 threshold and not have to disclose as a result, even though their aggregate contributions would be over the threshold. With regard to the third issue I wanted to cover, limiting exemptions of donors, we believe that the law already provides robust exemptions for most notably groups that lobby on civil liberties and civil rights. Individuals themselves can make an appeal to this body if they seek an exemption for a particular contribution, and 501c4 organizations themselves can provide forms to donors so that those donors can indicate that funds that they contribute should not go for lobbying but can still fulfill other activities like public education of a 501c4 organization. So because these robust exemptions already exist in the law, we would ask that JCOPE show great restraint in creating any others, particularly for the broad issue areas. And we believe that if they do so, if this body chooses to do so in rare circumstances, that it be backed up by data. And by data we mean real cases of harm, threats, harassments, or reprisals that actually exist. And those cases should be recent. They should be in the location or proximity of where the lobbying activity is occurring, and it should be any exemption should be subject to renewal and review. It should be temporary in nature. We know that lobbying on a particular issue in a time and place, the danger of donations given to entities, and the danger to that individual can change based on the era in which the advocacy occurs and where it occurs. We would also add that as far as definitions go, for the phrases harm, threats, harassment, or reprisals, that should mirror as much as is possible the penal code, so that a high bar is created and we don't have flimsy cases coming forth as a reason for exemptions. The same should be true for substantial likelihood. That phrase should be used to create a high bar for any exemptions that are granted. The last issue I'll talk about is related to the implementation and the effective date. As was stated earlier, the effective date in the bill is June 1st. There's a look-back period of 1 year. But we believe that fundamental fairness dictates that lobbyists, clients, donors, that they know the rules of the road that before donations are given. Therefore, we think that the rules should be promulgated, and then any donations made after that point should be subject to this law and rules, if that's permissible. I'm not a lawyer myself, but if the body believes that there's flexibility in this regard, we think it should be granted, because we're concerned about situations in which donors have given funds, as Barbara indicated, under the presumption that they were anonymous. And I think an argument can be made that the law was passed a year ago, and that provides some level of awareness. But at the same time, bills are passed all the time in Albany. This bill's 100-plus pages. Many people have not read it. I can tell you from personal experience, a couple weeks back, we had a fundraiser for our organization. A lobbyist actually came up to me about a contribution wanted it to be anonymous to our organization, and obviously was probably not aware of this law, and this is a lobbyist. So I think that if careful planning isn't taken with regard to these kind of contributions, there'll be a situation where there'll be much tension between lobbying organizations and their donors, and we wouldn't want to imperil the work that many organizations do that are 501c4s, not only just lobbying, but providing social services to the community. So with that, I'll wrap up, and I thank you for the opportunity to testify today and for your work in general, and answer any questions you may have.
Okay. Any questions?
Thank you, Chair. I note with great pleasure that the former Attorney General of the State of New York, Bobby Abrams, is a member of Citizens Union, and
That's right.
you're a great organization. And please give my personal regards to Dick Dady.
I will.
Let me just ask you some basic questions. You're promoting, on the one hand, that exemptions be looked at narrowly so that we have a high threshold not to exempt people. Yet you're starting the gate as late as possible. I mean, the earliest possible date Jacob could come out with would be January 1, 2011. Certainly August 15, 2011 would be, there'd be no surprise, there'd be no shock. So I don't understand this contradiction. On the one hand, you want exemptions held to the highest level of narrow reading, and yet you want reportability to be the exact opposite. How do you reconcile that?
Well, we made 12 recommendations. I think in general, as I mentioned from the outset, our overarching principle was robust disclosure. But there are circumstances in which we think disclosure will have to be limited, and I think the one example that we provided is when the clock begins, so to speak. And I think that's just because we think it's fundamentally fair to make people aware, lobbyists, clients, and donors, and the organizations, of the rules of the game before they begin.
Let me go to related sources for a minute. Are you familiar with the rather expansive definition that Senator Liz Kruger had in her proposed Senate bill?
I am not, unfortunately.
All right, then we'll pass. Are you at all, what is your view on the distinction between a 501c4 versus a 527 super PAC called Citizens United?
Well, my understanding with the 501c4 is that a 501c4 cannot do more than half its work with regard to lobbying. The other half can be public education, and my understanding is 527 organizations are primarily used for campaigning and not for public education and kind of social service functions.
What about the issue of linkage or delinkage in the 527? Can there be a linkage between an elected official and a 501c4 versus a necessary delinkage for a 527 super PAC?
Totally off point. Are you comfortable answering that question, sir?
Sure. I mean, elected officials are, I believe, legally able to consult with 501c4 organizations that are involved in lobbying. I think that's something that's permissible. Whether it's unseemly or improper is another question, but I think it's something that's permitted under the law.
I have a final follow-up for you. Given the current indictments in the Southern District on the John Lew's campaign activity and the issue of straw donors and the like, are you at all concerned that campaign contributions could be laundered through a 501c4?
I think that that's a little bit off topic. I don't think you need to answer that question in the context of this hearing. So
Okay.
Unless there are any other questions, thank you very much, Mr. Camarda.
That was my last one. Thanks.
Thank you.
Thank you very much for taking the time to come here and inform us. We very much appreciate that.
Thank you for the opportunity.
You're welcome. Next, we'll hear from Denise Wagner Furman, who represents New York Advocacy Association. Good morning, Ms. Furman.
Morning. Good morning.
And welcome.
My name is Denise Wagner Furman, and I'm here on behalf of the New York Advocacy Association, which is an organization, an association that represents advocates, government relations, individuals, and lobbyists. But I'm also here because I'm actually the person who does all of the reports for over 50 lobbying clients and their lobbyists. And so I come to you with a real practical point of view about the regulations and about the implementation of the law. I also am a citizen of New York. I'm an attorney. I'm a voter. And I'm a proud member or donator to almost every group that's on that right wall. And so I, too, am very supportive of the intent of the legislature when they passed this law, which was, and I'm going to just paraphrase a little bit from the intent, that the legislature declared that the operation of responsible and democratic government require the fullest opportunity be afforded to people to petition their government, to redress their grievances, to present their opinions about legislation and about the workings of government, but that there must be transparency, and to preserve and maintain the integrity of government, we must be able to see the identity of those attempting to influence government. There is nothing that makes transparency more muddled than huge amounts of information. If we were litigating and we had a discovery request and we're looking for documents from the opposing side, the best way the opposing side could just stifle us entirely would be by filling up a room like this with information. Having done New York City reports, New York State reports, lobbyist side reports, client side reports, let me tell you that the reports may within them gather the kernel of information. They may have what you need, but when also is demanded huge other parts of information, huge other data, you lose the needle in the haystack. And so what I would like to make sure of on behalf of the Advocacy Association is that it is the intent of the legislature that is carried out through regulations, and that we remember that transparency and sunshine is good for everyone. It's good for the lobbyists and the donors who are doing the right thing, who are participating in a democratic process, who are making their voices heard in a legal and legitimate way, and that they should not, first of all, be intimidated because they are concerned that wherever they donate money, it will show up on a list. Someone just came to my door the other day from the ACLU, and I wrote them a check. Now, if I write them a check and my husband writes them a check and maybe someone else in the family writes a check to the ACLU, are we going to show up on a list of people who contributed to lobbying? Even though we may have given that check for the purposes of other work the ACLU does, or not even earmarking it to lobbying. I think what the legislation does say is that the focus is to find those people or groups that donate $5,000 or more to a lobbying activity. And I think we have to keep in mind that that $5,000 should be to the lobbying activity. If I pay my Bar Association dues, if I pay for a number of continuing legal education courses to the Bar Association, and then that Bar Association also does lobbying, are the dollars I paid them for my continuing ed courses, for my dues, for maybe a contribution to a lawyer's support group, are those going to push me over the threshold so it looks as if I'm contributing to lobbying? I think that what we want to make sure of is that we know the people who are giving the big dollars for lobbying, and that you see them, and that it not be obscured by so much other information that's not relevant that you can't find the important things and you're tracking the wrong things. That's it for us. I'll certainly open to any relevant questions. And as a worker on the ground on these reports, let me tell you what we have volunteered many times before, and we will again. If you want to set up a practitioner support group, if you want to run by us or work with us as you're developing the forms so that we can see what will work, what won't work, we have a different perspective because we're putting the data in. You're taking it out. We can be very helpful, I believe, to making sure that the intent of the law is preserved and that those are the goals that are met.
Thank you, Ms. Furman. Any questions? Excellent. Thank you very much. Next, we have Mr. Russ Haven from the New York Public Interest Research Group. Good morning and welcome, Mr. Haven.
Good morning. Thank you. Ooh, quite a chair. My name's Russ Haven. I'm legislative counsel with NYPIRG, the New York Public Interest Research Group. We appreciate the opportunity to share our thoughts on these new disclosure requirements. Let me just make some preliminary comments. First off, I don't envy your task. You guys have a very tight deadline with a lot on your plate, and we understand that. We also understand that the timing and the way the legislation unfolded presents additional challenges to you. You guys, there was a so-called lag period between when the old commission went out of business and when you guys started up. So we understand that you're under, you're under constraints. And you're also constrained by what's in the statute. You can't rewrite it, and so you as the regulatory body needs to interpret it reasonably, and that's sort of the starting place for everything. And certainly, I'm going to be somewhat hesitant and reluctant, but I'll wait in anyway to offer the statutory interpretation given the quality of the attorneys, that I'm facing. But nonetheless, sally forth I will. And obviously, the information that we're talking about today with business relationships, with sources of funding, there's keen public interest in this and attention in this. And the real important steps forward, I think, the statute took over the predecessor law, and really the concept was that disclosure and information was going to improve and enhance integrity in New York. So the real magic, if there's magic in this new law, and we hope there is that more information will get out, that it'll be meaningful and useful, and that it will have a cleansing effect on the body politic, and will also help restore trust in state government in particular. So with that said, I would just add, as others have mentioned, we're asking you to move forward quickly, but also be deliberate. So we understand there's a mixed message there. So with that, let me just quickly go through some of the points, which we've also talked about in the previous submission to you all. I should say, as I've had discussions with other not-for-profit groups, in some cases attorneys in the not-for-profit world who don't have a dog in this fight, they don't engage in lobbying. It's become clear to me that the issues are more complex than I even first realized. So I think it's, you've got a big task in front of you to sort through all these issues and make sure you get it right. And while there's enormous pressure now to get data out to the public to fulfill the expectations that were created when we talked about this huge step forward in terms of the lobby laws, on the other hand, the rules you set up are going to be in place for quite some time. So you got to get them right. Not perfect. We realize the regulatory process is an evolving one, but you got to get them right so we get the information out to the public, but also so that everybody who's got to fill out the forms knows what they've got to do and can provide meaningful information to fulfill the purposes of the law. So just in terms of the reportable business relationships, in New York we have in particular a part-time legislature. So that means legislators and indeed many staff have outside jobs, outside business interests. And so requiring the disclosure by lobbyists and clients of their reportable business relationships will help shed light on what previously had been undisclosed. And that, in combination with the requirements that I think don't kick in until next summer from the public official side of the equation, will really be a game changer, we hope, in terms of giving the public information. So there's a potential for conflicts to be out there. There's a potential for appearance of conflict. And so what we're hoping is that the Commission will make sure that you elicit information that will shed light on these relationships. What's the true nature of the relationship? and enough detail so that something that isn't a conflict doesn't look like a conflict, but something that appears to be a conflict or is a conflict has ample information to let the public and you as the regulators know what's going on. For example, you're going to need information about how much money is exchanged, what was the subject matter of the transaction, and have enough detail to evaluate the relationship. For example, excessive compensation for goods and services might indicate a gift relationship. That's something obviously you want to be alert to. You want to have enough information. In thinking through why this law was going to be effective, what we liked was that we were getting information from a lot of different sources in different ways, and that would create sort of a matrix that you could compare and try and fill in the gaps, and try and get a fuller picture, sort of, the pointillistic approach that soon enough there's enough dots and pretty soon a clear picture. I hope I said that right. I'm not being smart major. And obviously you also have to create forms that make this easy to do, because as we've heard earlier, it's a headache. And to be honest, the lobbying commission forms are sort of a pain in the butt. And I mean that in a good way. We try and make sure we're getting the information to you. If the numbers don't add up, I know I'm going to get a call from the lobby commission, and we have, or where's page 3, or these numbers add up lower than your total, what's going on here. So you guys have been historically very, very detailed, in a good kind of pain in the butt kind of way, about making sure the details, and now you're going to need to make sure that's the case with these forms. In terms of disclosing this information, you need to make sure it gets disclosed in a way that's useful to the public, that they see the business relationship when they look at the legislators' ethics forms or the staff person's ethics forms, and that it's a way that's useful and can be cross-referenced. Funding sources of lobbying activities. So as we've heard, there's a new provision on this. And so the threshold question is who has to comply and when do they have to comply. And so what I attempted to do is parse this language, and here's the way I tried to suss it out. First, there's a two-pronged test to determine whether or not a particular lobbyist or client meets the financial criteria, and they're required to report under the source of funding provision. And then the second part is that there's time parameters that apply to that two-pronged test. So if you have the 3%, $50,000 test, if you meet that prong of it, then there's a question about what time period you need to look at, and those obviously are related questions. Third, there's the question of how do you deal with the timing requirement for the funds that were used to support the lobbying activity. And fourth, there's the exemption provisions that will apply to certain organizations that have a reasonable threat or fear of reprisal to those donors. As others have mentioned at the outset, we recognize the challenge before you because there were no transition provisions. What the legislature and the governor did is they dumped these provisions into the ongoing rules about reporting. So instead of saying, here's how you deal with this in the kickoff period, what you're left with, as you well know, is a section of the law that kicks in June 1st, which happens to be in the middle of a bi-monthly reporting period for lobbyists and a semi-annual reporting period for clients. So that obviously creates some questions. In terms of the period that you would look at, or as someone framed it, I think the look-back period for the financial criteria, I think it's probably reasonable to say that either you're going to look at calendar year 2011, because the statute refers to calendar year, or you could look at the 12 months immediately preceding the effective date, which would be June 1st, 2011 to May 31st, 2012. That seems like a reasonable reading to me. Again, that's not what you're reporting on. That just sets the parameters of how you know whether or not you have to report. So that was our reading of that. Once that's determined, then you have to figure out who meets the $50,000 3% test. And then there's some question in the law about, it seems to be, is that a rolling basis? Is it the 12 months preceding you at any time, or is it the calendar year? Or it could be either, whichever gets you through the door. That's something you guys are going to need to figure out. Appears like the rolling threshold or the calendar year, whatever you decide, it seems like there's authority, or both, whichever gets you to the threshold, it seems like that's a reasonable interpretation. And you know, I'm going to repeat myself on this, but you guys really need to provide clear, specific guidance on how reporting community needs to construe this. And I should say, and I think you guys are sensitive to this, but that you need to be available for consultation, you know, to people to talk them through this. And I think you're going to be spending a good deal of time on the phone, as you know, as you've historically done on these questions. But particularly at the outset, I think you're going to need, a call center set up. Reporting the timing of source of funding. So the statute requires disclosures of the sources of funding for the reporting period, it seems to say occurring after June 1st, 2012. So the first reporting period would be the July 15th bi-monthly for lobbyists, or the semi-annual client report due on that date. And there's a little bit of a disconnect, because if you have an outside lobbyist, it seems to me, if I read it correctly, you're only going to report twice a year, but if you're lobbying on behalf of your own organization, you're going to report bi-monthly. So you're going to get different reports on the same information. It seems to me it really should properly be a client report. That doesn't appear to be what the legislature directed you to do. If you have some way to streamline that, it seems to make sense, but you may be, you may be hemmed in by what the statute says. But it seems to me we're really talking about the client here, or the function of the client when it comes to the reporting, even if you happen to have your in-house lobbyists. So it seems like the statute refers to making information available for those reports starting after June 1st. You could make an argument that certainly for the reports, the semi-annual client report, that report covers the first 6 months, and therefore it should cover that period. I wouldn't say it's a stretch. I just think that, in fairness, the rules of the road should be in place before you're required to report. But if you did that, you might find support in the statute. I think that I think the more reasonable interpretation is that the rules kick forward after June 1st. But there might be some support for that. But I think, again, in fairness, the equities tip to making it prospective after that date. But again, that's one of the things you guys are going to have to struggle with. And certainly we'll continue to look at this. And then there's all these issues about funding disclosure, and I won't go through some of the questions that people have raised with me as I've talked to them. But what do you do if an asset like stock or real property is donated, and at the time it's not worth $5,000, but it escalates? So you got 150 shares of Facebook, and it's not worth $5,000 now. But and then it goes up.
We should all have that problem.
Right. Yeah. So should my organization. So what do you do about that? Or what do you do if you raise? An organization raises $1 million in $5,000 contributions during a reporting period, but they only spend $20,000 in lobbying. Do you disclose all 200 donors? So there's a lot of interesting questions, and I'm sorry to say I don't have clear answers for you guys, other than try and think this through and be as clear to us and others as possible, so we can report honestly and fully and get you the information to fulfill the purposes of the law. And it may mean that you're going to get into the arcana of bookkeeping for not-for-profits and things like that. But any again, be as specific as possible, and I think that'll make the disclosures more successful. With respect to the waiver issues, I should start off by saying NYPIRG certainly doesn't anticipate seeking an exemption under this provision. I do know we've had threats over the years, but in general, I don't, I just don't see us ever, I shouldn't say ever, but we, based on what I know, we wouldn't invoke this. But nevertheless, we were sensitive to this, and in the discussions about the legislation, this is what drew the most attention with respect to this provision. And we took a lot of comfort in that civil liberties groups were consulted. Nevertheless, I think you are going to need to be specific about which groups are covered, what types of groups are covered. And this is a balancing act. Everything's a balancing act here because we're talking about, on the one hand, First Amendment activity, on the other hand, the public's deep and important interest in getting information about who's trying to influence government. I thought some of the recommendations about periodic review of agency's mission and shifting landscape, what might be controversial today may not be so in the future, and what doesn't seem so controversial now could be an inflammatory issue going forward. So I think you're going to need to be sensitive to that. I guess those are our overarching comments. Again, we understand the challenges that you have in translating legislative statute and policy into an implemented law. And cheer up, this is only round one. That being said, again, we think the biggest advancement offered by this statute is that it sees information as really a key way to bring integrity to government and maintain public trust. And so we're hopeful we can work with you to achieve those goals and make this a success. And, I'll take any questions.
Thank you. Commissioners, any questions? Any questions?
I have four. One, the first one dealing with exemptions. You heard Barbara Bartoletti's comments that she really thought about the fear and harm and reprisals really being about Planned Parenthood, and there's a great deal of history about that, and I frankly had the same mindset. But I'm troubled that you've said you've received threats over the years. What kind of threats have you received in terms of NYPIRG?
Well, we've worked on issues like gun control from time to time. We worked in Congress to regulate firearms as a consumer product. We didn't really lobby on a state level, but we were somewhat visible on that. Some of our positions in opposition to incinerators drew unhappy comments and communications from folks who were concerned about job loss. Those are two things that come to mind. We've done a lot of work on tobacco control, and smokers are unhappy when we're trying to stop their cigarettes from causing fires or make the cost of a pack of cigarettes more expensive. So I'm not saying those are in the category of Planned Parenthood, or we could name organizations and advocacy issues on any side of the spectrum. But nevertheless, I sort of understand that this is a real issue for some groups, and there's obviously Planned Parenthood is one of the best examples of civil rights organizations.
But did I hear you right that you don't expect NYPIRG to be claiming an exemption?
I do not.
Okay. Do you think that the definition of exemption should be narrow or broad? Because you understand if it's narrow, then there's more disclosure. If it's broad, it's less disclosure.
The principle, I guess, is whether or not there's a well-founded fear of reprisal for your donors if their names are disclosed. putting aside the general privacy concerns of people not wanting to be done, have their, name on a donors list. I think that's what's got to guide you. So it's hard for me to say what the broad categories are, but I think that's the principle. You want people to feel that they can contribute to organizations that advocate on issues of interest to them, and that they won't,
Let me go to my second question.
Yeah.
Look back. And I want to have you focus just in a moment on ex post facto concerns. The law PIRA came into effect August 15, 2011. Do you feel there's a constitutional infirmity if we were to look back beyond August 15, 2011?
I didn't really get to the constitutional issue because, in my view, the statute demarcates how far you can go back, and my read is I don't think earlier than January 1st, 2012. Again, not
Right.
earlier than January of this year. If again, there's this other provision that deals with, do you get in the door because you spent $50,000, which was 3%? That clearly you can go back before the first of the year, but I think the language that deals with the reporting on the monies that were the subject of what you've reported, that ties it to.
I'm a little confused.
Yeah.
If PIRA came into effect August 15, 2011, why can't we at least set a date starting from that point?
Because
The law was signed by the governor.
Well, but it wasn't. I mean, it was enacted on that date, but this provision wasn't effective, as I understand it, until June 1st, 2012.
That's only a reporting requirement, but everybody in the state of New York knew it was coming, so they knew they had to keep records because they knew they had a reporting requirement. So,
Well, that may go to the constitutional
That's
issue.
what I'm asking you.
Yeah, no, I never got there because I read the statute effective date in that way. So you may be right. That may be reasonable. I'd have to go back and take a look at the
I'll go to my third
constitutional
area.
stuff.
On related sources of funding, what do you think about JCOB in its deliberations considering Senator Liz Krueger's wonderful and more expansive definition?
I agree that Liz Krueger is wonderful. I'm not familiar with the language. I'd be happy to take a look and get back to you.
Then let me go to my last question. You raised from all the speakers, you're the first one to raise this issue about money raised but not spent. From the little I know about politics, I know that money not spent can be as powerful a tool as money that is spent. In fact, a cop on a beat will tell you that an unfired gun is more powerful than one that's been emptied. So why do you think that if money's been raised but not spent, should somehow not be disclosable?
Well, I was posing that as a question because it sort of puts the issue into relief. But the language in the statute, again, that's sort of what you're dealing with here, talks about sources of funding used to pay for the activities that were reported. So you have to, I think, statutory interpretation, you have to give the legislature's words some meaning.
Thank you very much.
Okay, thank you very much, Mr. Haven.
Thank you.
You're welcome. Susan Lerner from Common Cause. Good afternoon.
Good
Ms.
afternoon.
Lerner. Thank you for coming.
Thank you very much. First, I would like to thank the Commission for starting this process with public comments and with open hearings, rather than diving into this difficult area with regulations before you've had an opportunity to hear what the concerns are of the public and people who would have to report. That said, I would like to agree with my colleague Russ Haven. You have a difficult task ahead of you, which unfortunately the legislature did not help you with by having any kind of hearings that would allow some of the concerns that have been raised to have been more properly addressed in the statute. Just something as simple as the June 1 start date probably would have come out immediately in hearings, and it could have been adjusted so that the start date for these provisions would have been consonant with the reporting requirement instead of talking about fractions of reporting requirements, which makes it a little trickier. I'd like to concentrate primarily on the source of funding reporting, and then talk a little bit about reporting in general. I have written comments. I'm not going to read either the comments or the testimony, but rather to highlight some things. And also, again, congratulations. You are right in the middle of a national discussion about what should or should not be disclosed in terms of contributors. So you're really at the cutting edge. But that also means that there are a lot of people who are talking about this. It isn't in the context so much of lobbying funding disclosures, because this statute is really a very forward-looking one, and pretty much of what we hope to be the cutting edge for these kinds of disclosures. But the discussion that's going on right now is in the campaign finance world. And there is extensive discussion among scholars, among practitioners, among those of us who struggle with campaign finance questions, and I've cited in my written testimony to a law review article, which I think is written by someone here in New York, coincidentally, that deals with these issues in a broader sense in terms of disclosures of members, disclosures of campaign contributions. And also here in New York, we've had some guidance from a federal court in terms of a lawsuit that was brought by the National Organization for Marriage challenging campaign finance disclosures. And so we think that there is some guidance, not only from the U.S. Supreme Court in terms of a heavy emphasis towards broader disclosure as a general principle, but also some instances where courts and others have been struggling with what's the right line of demarcation of who should be disclosing and what they should be disclosing, which takes us right into the statutory language regarding the exemption. And there I agree with my colleagues who say that we believe at Common Cause that it should be a narrow exemption. And we talk about, in my testimony, I point to some specific examples. And we are also concerned, we're very glad to see the language that specifically exempts civil rights and civil liberties groups, concerned that it did not also include groups which deal with very volatile reproductive health issues, because that is the area where, unfortunately, in the last 10 years or so, we have seen the most actual physical violence and real tangible threats to health and to property, to life and to property. And so we would be very supportive of a regulatory approach which recognized the dangers in that community to the disclosure of donors. In terms of the question of statutory interpretation, there are two things I'd like to talk about. One is the entire question of, well, how do you deal with over-disclosure? The example that was brought up by a prior testimony of, well, if I'm paying for CLE through the Barr Association or something of that sort, I would argue that's really not a close call. The statutory interpretation is money which is used for lobbying, and there really is no interpretation. If your money is designated for a specific purpose like CLE or purchasing a publication, then I would say that I believe that that probably exempts that money from aggregating towards the $5,000 disclosure requirement. It's more in the way of general funds and general support, which I would anticipate would be disclosed. And I would love to be in the position of having $1 million that came in $5,000 amounts that we would disclose. I am not troubled by the idea that you would disclose all of that because, again, without segregating the funds in some way, which most of us do not. We have our general operating funds. We may have some specific funding for a particular project that is usually pretty well earmarked. Some portion of the monies that we take in for our general support when we do a fair amount of lobbying is going to go towards lobbying and the office support and so forth. So to me, I would keep it as simple as possible and say that the amounts are reportable at the time at which it's received, and the aggregate goes over $5,000. Obviously, if you're getting a $10,000 check, that's pretty easy, but certainly a cumulative contribution that $2,500 from a donor, then followed by $4,000. When you receive that $4,000 check, it's reportable, it seems to me, in that time period, as that donor then becomes somebody who should be identified. And I would keep it as simple as possible and tie it to receipt. The other thing that I think really is an interesting question, and one that I think you are hearing different interpretations, is what has been referred to as the look-back provision. I believe that the statute sets up a retrospective reporting system in general, that we're not required as a reporting entity to try and anticipate what we are going to lobby on, but rather to accurately report the amounts that we have spent in the preceding reporting period on lobbying. Similarly, I believe that in that context, the public is on notice from the passage of the statute, from the extensive press coverage that it received at the time in which it passed last summer, and a general attitude that once a statute is passed, we have the, I think, appropriate attitude in the law that people are on notice that it is going to be effective as of a certain date. And we don't provide grace periods for other statutes that we require the public to follow. Why would we provide a grace period here where there already has been, built into the statute, a grace period of almost 12 months? And it seems to me also that when the statute talks about retrospectively within the last 12 months, that it is appropriate for that look-back period to be a 12-month period, which leads me to when does it actually kick in? It seems to me, again, simplicity is the easiest to follow. We have a reporting period of July 15th, that the reporting should begin with that reporting period, and it should cover the time period within that reporting period. That, to me, is the effective date. Lastly, I'd like to talk about just the general challenges of reporting. Certainly, we're an entity which both advocates for broad reporting requirements and struggles with filling out our forms on a semi-monthly basis. And one of the things that we have consistently recommended in reports and evaluations which we have done of different reporting systems is to argue for as much uniformity in reporting as possible, because we not only report, we also deal with the reports. And it seems to me that JCOPE has an excellent opportunity as a new entity to take a look at the total package of reporting and to try and standardize as much as possible. That would lead to a conclusion of as much electronic filing with pull-down menus as you can possibly set up. I know that that's a difficult situation because you don't have the budget to completely redo your online presence, which this would require. But I would suggest to you that in your deliberations and in discussions with staff, to the extent that this reporting can be set up electronically with forms that you can easily fill out and then just pull down in the future, it will standardize the reporting. It will make it easy for large and small organizations to be sure that they are accurately filing, and it will make it easier for those of us who look at these reports to actually be able to, and other members of the public, to actually see what the filings are and to minimize the kind of confusion we get when we're looking at 4 or 5 versions of the same name and trying to figure out, is this the same entity, because different staff people at an organization filled out the form and they used a different abbreviation, and therefore it shows up as an entirely different reporting entity when it's actually the same one. So those are the summary of my comments.
Thank you, Ms. Lerner. Any questions?
First of all, Ms. Lerner, thank you for your very principled leadership in the state of New York. After having said that, let me ask you a tough question. What is unfair about allowing people who work very hard and become wealthy to exercise their First Amendment rights to the fullest as allowed by the United States Supreme Court and Citizens United? And the message from that?
I'm not sure I understand the question in the sense that we don't, I guess I need a little further expansion of what you're getting at.
Of course, Citizens United dealt with 527s and not 501c4s, but do you see any concern to democracy in terms of 501c4s, given the Supreme Court lesson to all of us?
Yes, I do, actually, and it's an area that I talked about in my written testimony and forgot to mention in my summary, and that is that the 501c4 form has been used in the last, I would say, 10 to 15 years in different places across the country as a cloak and a shield from disclosure. I spent a part of my career in California, and one of the issues that showed up, that began to show up rather frequently on initiative campaigns, was significant amounts of money which, in a normal campaign structure, the source of which would have been disclosed to the voter, being passed through several different interlocking 501c4 organizations, so that it was actually impossible for the voter to determine who was backing a particular initiative and make an informed decision as to the credibility of the source of the representations made to support the initiative. And quite frankly, we see something similar right now in the controversy around the Committee to Save New York, which is only the latest iteration here in New York of a series of committees that have been formed to try and influence public opinion without actually letting the public know who was speaking to them at the time of the speech. We issued a report about this last year, where we talk about veiled political actors, and we were looking at specifically the use of committees to fund grassroots advertising. And I think it's really a question of a vigorous democracy requires an informed citizenry. And any informed person would want to know the credibility of the person who is trying to sell them something, which in essence is what that kind of grassroots lobbying is. It's the first thing that you ask. Who's the salesperson? I'm buying a used car. Who am I buying it from? Am I buying it from an individual and I'm trying to make a decision whether to trust him or not, or am I buying my used car from a dealer who has a reputation that I can then check? When we have a lot of information and a lot of selling to the public and to the legislature through innocuous named entities, we put the ordinary citizen and the informed, engaged citizen at a disadvantage because they don't have the information, the basic information necessary to do the first line of evaluation, which is, should I pay any attention to this or not? Somebody who feels very strongly that ExxonMobil is an important member of our energy policy is likely to be more interested in what ExxonMobil has to say in public messages than they are perhaps in messages from the Sierra Club or NRDC. They should have that basic information on these important issues of public policy and public concern. And that's why in the written testimony I talk about the challenge of trying to figure out affiliated organizations and deal with what in the campaign finance world we call the Russian doll problem, which are these interlocking C4 organizations where you peel back the first layer and what you have is another C4 organization. In some situations you're then stopped from seeing who actually is the source of the money, And I suggest in my written testimony that that is an issue that I believe the Commission should try to struggle with, and I think there is room within the statute for going further than just the first layer of disclosure, and there are limited but some models in other places for that.
Let me just quickly cover the rest of it. In terms of look back, when you say that you would recommend that the reporting period of July 15, 2012 be the period effective, what's the starting date as you envision it based upon that date?
I believe it's the entire period for reporting.
So would it be from June 1 of 2011 through?
No, it would be for the semi-annual, it would be the 6 months preceding, which would start January 1 of 2012 through June 30 of 2012, and then it also would be the 2 months, which would encompass May and June of 2012. I think that's the fairest way to handle it, even though I would like to see disclosures that begin earlier. I think on the statutory framework, I feel that there is that constraint.
Do you believe that that is a statutory interpretation you're making based upon when the filing report was put into the statute?
Looking at the entire regulatory framework of how you report and looking at when the reporting requirement becomes effective, trying to harmonize those two when you have a June 1 date, the conclusion I came to is that the reporting requirement should be effective for all reports that are due post June 1.
Okay, so, but you don't have an ex post facto problem, do you, if it was to start earlier?
I don't, because I believe that at least from a minimum of August 15th and arguably from June 14th of 2011, the public has been on notice that this is going to be the law.
Final question.
Or is the law.
Final question. Do you see any prohibition in Jacob utilizing Senator Liz Kruger's definitions in her May 3rd, 2011 Senate bill as part of his deliberation?
I recall being impressed by those definitions when I reviewed them back then. I don't have them in mind, but my sense is that they probably come very close to the kind of affiliation that I talk about when I talk about peeling back and the various layers of organizations in the Russian doll problem.
Thank you very much.
Thank you.
Thank you, Mr. Knapp. Okay, thank you all. This concludes today's hearing, and I want to thank each of the presenters who took the time to come here today and inform us of your views. I'd also like to thank my fellow commissioners for the time and attention they've paid to this matter, and thank you all for being here.